Hey guys, Brian Felfel, Law Group PLLC here with your Florida Law Weekly case update. I got two cases and some rule changes for you this week, so let's get right to it. So the rule changes, I don't know if these rule changes apply to the family law rules of procedure. Right now, they're just for the civil procedure rules, but there's some big changes coming starting in 2025, January 1st, 2025. Big changes across the board. Essentially, seems like the court is really going to the federal rules of civil procedure and pretty much adopting mostly all of them, at least all of the major ones, in some way, shape, or form. So, for example, the scope of discovery under 1.280, general scope of discovery, it used to be reasonably calculated to lead to the discovery of admissible evidence. No longer. It's no longer that. Now it's proportionality. So it's got to still be relevant to the case, but it's got to be proportional to the needs of the case. Got to look up the standard for that. So don't be citing, oh well, this is reasonably calculated to lead to the discovery of admissible evidence. That's no longer the standard, at least in civil cases. I haven't seen anything applying this to the family law rules of procedure. So family law rules of procedure, it seems like will still be the standard of reasonably calculated to lead to the discovery of admissible evidence. But for the civil cases, no longer the case. Also, summary judgment, at least in civil cases, the time frame, it's no longer going to be tied to the date of the hearing, and then 20 days before the hearing is when the response is due, and the motion has to be filed 40 days before the hearing. It's now going to be so you file your motion for summary judgment, and then the response is now due 40 days after the motion is filed. And then the hearing for the motion for summary judgment cannot be set until at least 10 days after that, after the response is filed. So that's a big change. And now the civil cases are going to these discovery orders and these case management orders, just like in federal court. It's going to be the order's really going to set forth exactly the time frames, the deadlines for discovery cutoff, and all that good stuff. Other changes include to your request for production, your interrogatories. Specifically, if you're going to object, no longer can you just say objection and have like a blanket objection. A lot of times we would argue that's not good anyway, even under the old rules. But now specifically the rules say if you're going to object, either interrogatory or request for production, you really have to specifically say what is the reason why you're objecting. Not only that, especially if it's a request for production, you have to specifically say whether you're withholding any of the documents based on your objection. So you can't just be like, okay, objection, and then, litigate it later whether you actually have the documents. You have to specifically say whether you're withholding any documents based on your objection. You have to produce the documents that you're not withholding. And same thing sort of with the interrogatories. You have to disclose the information that you're not objecting to. You really got to be specific, and so you can get sanctioned for these now. So, you got to be super, super careful with this. There's a bunch of other changes as well, miscellaneous changes to the rules. So really got to be careful with what the new rules are. Another one I just remembered is, for example, for setting trial, it's no longer that the case has to be at issue, which is really very strange to me. Like the pleadings are closed, so technically the court, under the new rules, the court can set trial even though the pleadings are not closed. The case is not at issue. You don't have to actually say that anymore, apparently. So we'll see what happens. But right now, I didn't see anything applying this to the family law rules. But if you practice civil litigation or if you're suing somebody, you really got to be careful with these new rule changes. And they'll probably come to the family law rules in some shape or form at some point. I'm just not really sure when. As far as the cases, a couple cases I thought were interesting. First one is a really important point. It has to do with voluntary dismissal. So say, for example, you sign a marital settlement agreement, you file it with the court, your spouse files an answer and a waiver and requests a final judgment. But then you get thinking and you're like, wait a minute, I don't know if I really want to get divorced. I'm not really sure if I'm comfortable with the settlement agreement, whatever. And you file a notice of voluntary dismissal. That ends the case. So your spouse, for example, in this case, the husband was out of luck. He actually complied with the settlement agreement, started making the monetary payments and doing everything under the settlement agreement, only to have his wife file a notice of voluntary dismissal. Case is over. That's it. It cannot be revived. So if the husband wants to do something, get divorced, enforce the settlement agreement, he's gonna have to file a brand new action, pay a new filing fee, etc. So super important concept to know about. Voluntary dismissal ends the case. Okay, next case and the last case is Lapomarede versus Pierre. This is out of the fourth DCA, and has to do with what are you allowed to present at trial as far as parenting plans compared to what you pled. So in this case, the person who was appealing was basically saying, well, my spouse didn't plead specifically for this week on, week off time sharing schedule. So they were kind of saying, well, I was denied due process. I didn't, if you have to plead it in order for it to actually for you to get the relief that you want. And so that's what this person was saying. But what happened was, if you're going to object to somebody having something outside of their pleadings, like a specific parenting plan or something like that, you really have to object to it at trial. You cannot try it by consent. So that's what happened here. It was tried by consent, and the spouse actually, I think it was the husband, actually filed his proposed parenting plan with the week on, week off schedule before trial. And I guess the wife didn't object to that. So super, super important. You really got to make sure you're going to object. If you're going to object, you got to do it. You can't just, later complain, oh, but they didn't put this in their original petition. You got to actually really object. Otherwise, the issues could be tried by consent. Object throughout the trial too. And the final thing in this case has to do with a loan, and sort of like the inverse of dissipation, when somebody claims that a spouse dissipated assets during the marriage, or right before the dissolution was filed, during the proceedings, I meant, or right before the dissolution of marriage action is filed. People do this all the time. They claim dissipation, but remember, you have to actually show that there's misconduct and that there's actually some sort of nefarious spending going on here. It can't just be that they spend it on their ordinary living expenses. Well, this case it wasn't depletion of assets. It was incursion of debt. So the wife, apparently she took out a loan right before she filed for divorce, and she essentially consolidated her credit cards, and I think actually in this case, no, it was her medical bills, and then a loan from some third party. So I think the husband was probably really complaining about this nebulous loan from third parties that she consolidated in a new loan and paid it off, incurred new debt. And so the spouse was saying, wow, well, that's sort of similar to dissipation or whatever. Asked for an unequal distribution of assets, and the trial court actually granted it, but that got reversed. You can't really do an unequal distribution of assets based on just a loan like that, unless the other spouse really shows that this person incurred the debt for a non-marital purpose, for purpose outside of the marriage, for something that wasn't just ordinary expenses or something like that. So the fact that this loan was admittedly used to pay for the wife's, I think it was like her hospital expenses when she was giving birth or something along those lines, reasonable medical expenses during the marriage, it's still good, even though it included that loan from the third party. So if you want to prove dissipation, or prove that that a loan should not be distributed equally, you really got to show and prove why. Got to show evidence and prove it. All right, guys, that's it for this week. Remember, if you fell out of love, call Fell Law Group. Take care.